Welcome to meeting number 128 of the House of Commons Standing Committee on Indigenous and Northern Affairs. I do want to start by acknowledging that we are gathered on the ancestral and unceded territory of the Algonquin and Anishinaabe people, and to express gratitude that we're able to do the important work of this committee on lands that they've stewarded since time immemorial. But also, before going any further, it's with sadness that I want to start our meeting today by taking note of the passing of the Honourable Murray Sinclair. Mr. Sinclair was a pioneer in Indigenous law, a revered elder, senator, and a tireless advocate for justice and reconciliation. Senator Sinclair's legacy is deeply embedded in the heart of this nation, from his work as the first Indigenous judge in Manitoba to his pivotal role as chair of the Truth and Reconciliation Commission. Through his wisdom, compassion, courage, and commitment to building consensus, Senator Sinclair illuminated the painful truths of residential schools and provided Canada with a path forward through the 94 calls to action. His contributions have forever transformed our collective journey towards reconciliation, leaving an indelible mark on generations to come. His work as a pioneering Indigenous lawyer laid the way for many, and indeed helped inspire me to get into this line of work as well. So our thoughts are with his family, friends, and all those that are touched by his work and spirit. We're grateful for his life, his vision, his service, and contribution to Canada, which will continue to guide us as we walk the path of healing and justice. Miigwech. And I know there are a number of members of this committee that had asked to make an intervention to comment and to take note of this passing as well. So I'd like to open it up to members of the committee here. And I know it's very difficult to do this in 90 seconds or less, given the incredible contributions of Mr. Sinclair to our country. But if you could try to make your interventions within that framework, that would be much appreciated as well. So first I see Mr. Carr has raised his hand.
Well, thanks, Mr. Chair. I appreciate the opportunity just to speak very briefly about Senator Sinclair. I first got to work with him in earnest when I was a young staffer at Canadian Heritage, and we were trying to pass legislation that would help to protect Indigenous languages in Canada. And Murray was the person that we always turned to for advice and guidance. And it was remarkable to watch how measured he was and how wise he was. I was truly in awe of him, and I had never seen, and to this day have not seen, a public figure as universally revered as Senator Sinclair was. When I returned home after working here in Ottawa, I got back into education, and I had the fortunate opportunity to work with him in a variety of other capacities, because he was always very active in helping educators in Manitoba and across the country make sense of where we were going and building upon the foundation that he had laid through the tremendously important work in the Truth and Reconciliation Commission. And what I am thinking about today, in addition to, of course, Senator Sinclair and his family, including his son Nigan, who was a teacher of mine in high school, is that he was famous for saying that education got us into this mess and education will get us out of this mess. So it's truly a privilege around this table, Mr. Chair, and with colleagues as we discuss the important work ahead as a representative from Manitoba to have the opportunity to pay tribute to Senator Sinclair. Thank you for the opportunity.
Thank you very much, Mr. Carr. Next I have Mr. Hanley.
Thank you, Mr. Chair. Leadership, learnedness, wisdom, compassion, composure. Those are some of the words that come to mind as I think of Senator Sinclair. Indeed, I consider Murray Sinclair a founding father of truth and reconciliation for Canada. But I'd like to give a more personal perspective. I first met Mr. Sinclair when he came to a special meeting of the Yukon Medical Association in 2014. And I would say that that meeting was a turning point in our medical community's journey of reconciliation. For many physicians, they had heard of residential school but never quite related that history to clinical encounters, how residential school experience, either direct or through generational trauma, In other words, how one child's direct experience in residential school carries that trauma on through the generations. And that trauma, in turn, influences not just the health of First Nations people, but whether they present for care and how they present for care. It's so important for healthcare providers to understand the enduring effects of residential school, and Mr. Sinclair was instrumental in laying the foundation. I remember feeling in myself how I transformed from more or less superficial knowledge to the beginning of a much more profound understanding. There were many tears in a silent and captivated room when Mr. Sinclair spoke, and I could see the light of realization coming into the faces of many of my colleagues. An expert in law, residential school, and Canadian history, but ultimately a person who is able, through his personal experience, to tell the story of residential schools that went straight to the heart, inspiring a commitment not just to listen and to understand, but to actively participate in undoing the wrongs of the past, to integrate awareness of systemic racism, and to do better in meeting the needs and recognizing the leadership of Yukon First Nations. So thank you, Mr. Sinclair, for all that you have contributed to Canada's growth in truth and reconciliation, and I extend my sincere and deep condolences to Mr. Sinclair's family. Thank you, Mr. Chair.
Thank you very much, Mr. Hanley. Next, I'm going to turn the floor over to Mr. Schmale.
Thank you, Chair, for the opportunity to say a few words to celebrate the remarkable life and achievements of a true champion of justice and reconciliation, of course, the Honourable Murray Sinclair. He was a distinguished lawyer, a senator, and the first Indigenous person to serve as Chief Justice of the Manitoba Court of the Queen's Bench. Justice Sinclair's journey was a testament to the power of resilience, advocacy, and vision. As we know, he was born in 1951 in the small community of St. Peters, Manitoba. He faced a number of challenges as a member of the Selkirk First Nation. His early experiences instilled in him a profound understanding of the injustices faced by Indigenous peoples in Canada. Rather than being deterred, he channeled his experiences into a lifelong commitment to advocacy and change. And of course, his educational path was nothing short of inspiring, obtaining his law degree from the University of Manitoba in 1979, and was one of the first Indigenous lawyers in Canada. And of course, that law career just flourished. But I think it was his role as chair of the Truth and Reconciliation Commission that truly brought him to the forefront of the national consciousness. Of course, that happened in 2019. And I think, as many have said, his work has had a profound impact on countless lives. Its advocacy for education, justice, and health equity for Indigenous peoples. It's inspired a new generation of leaders. And of course, it was mentioned earlier on that one of his quotes that he is well known for, he has many, but education is the key to reconciliation. Of course, as Mr. Carr pointed out, education got us into this mess, and education will get us out of it. And I think, as was pointed out earlier, aside from his formal roles, he was a mentor to many. He was a role model, a beacon of hope. And I think that is a very quick synopsis of what he did, but it could go on for much, much longer. So I appreciate the opportunity, and on behalf of the official opposition here, like to express our deep gratitude to Justice Murray Sinclair for his unwavering dedication, his wisdom, and his profound humanity. And I wish to extend condolences to his family and friends. May he rest in peace.
Thank you very much, Mr. Schmale. Next, I have Ms. Idlaut.
Thank you, Chairperson. Regarding Justice Sinclair, I do have a short message. We all know that he has tremendously helped Indigenous people, especially regarding the Truth and Reconciliation in that movement. And I share my love to his family. They are going through a difficult time. Although his children are getting older, it's the loss of a parent. That we feel the empathy. They did say that they don't want to receive any flowers instead of in replacement of sending flowers, you can make a donation to Murray Sinclair Memorial Fund and, at the foundation. You can make a donation to the foundation. That can be given to the family. So that can really help the family. He has really put us on a higher level as Justice Sinclair to Inuit, First Nations, Métis. So he has brought us up.
Spirit world.
Thank you.
Very much, Ms. Idlout. Next, I'm going to provide the floor prochain pour Monsieur Lemire.
Merci.
Thank you, Mr. Chair, and thank you for this initiative and to all of our colleagues that have shared their kind words to Justice Sinclair and his family. I'd like to offer my condolences on behalf of the Bloc Québécois as well to his loved ones, to his community. He has a great legacy, especially in the context of truth and reconciliation. He has been an inspiration for us and for this committee's work. I'm particularly touched when I see men and women of that generation that have experienced residential schools and that have dared to raise their voice and talk about the suffering and the trauma that they have gone through. And they have inspired change in our society, change that will bring greater respect and has brought greater respect to Indigenous communities. And he has done great work for truth and reconciliation by sharing the truth. And I'm grateful that he has done so. And I hope that we will have that opportunity to also speak the truth and make decisions as MPs that will be respectful of the suffering that they have gone through. Thank you, Mr. Chair.
Merci beaucoup, Monsieur.
Thank you, Mr. Lemire.
Next, I'm going to hand the floor over to Mr. Batiste.
Thank you, Mr. Chair. And we have a somber day here in Ottawa as we reflect on a life well lived. Murray Sinclair was an amazing person. He had tremendous influence all across Canada, and I can think of no other person who advanced reconciliation over the past decade more than Senator Sinclair. But long before I was a member of Parliament, I was a treaty education lead in Nova Scotia, going around the Atlantic, speaking his words, quoting him, and his passion for the education system. And one of the quotes I always remembered in my presentations from Murray, he said, "While Indigenous children were being mistreated in residential schools, being told they were heathens, savages, and pagans, and inferior people, that same message was being delivered in the public schools of this country." And he said that to awaken Canadians to the fact that we needed an education system that not only spoke about the truth and about the Indian residential schools, but also about our true shared history in this country, all of it. As a member of Parliament, I was able to co-chair with him the Indigenous Senators and Parliamentarian Group, where we had a belief that no matter what your political affiliation was, no matter where you were, wherever you grew up, that if you were Indigenous, that we could find common ground on things. And I always remember that, and he'll be well remembered. And I just want to say Wallalin to him for his legacy, but also to his family, Miigwech, for sharing him with us. And we're thinking about you in our prayers right now.
Thank you very much, Mr. Batiste. I'm going to turn the floor over at this point to Mr. Melillo.
Thank you, Mr. Chair. Thank you for affording us all this opportunity, and I'll try my best to be brief as well. I don't want to reiterate or repeat anything that's been said, but obviously Senator Murray Sinclair had an incredibly profound impact on, I think, all of us, and I would say many, many Canadians from across the country. He was instrumental, of course, in advancing reconciliation, and his life, his career really speaks for itself. Incredibly impressive resume in every respect. And from my own standpoint, as someone representing Northwestern Ontario, 42 First Nations across 3 treaty territories, I know from conversations I've had, he's more than an inspiration. He's really a hero to many people, many First Nations across the country. And obviously he's going to be very missed. I know he will not be forgotten because of the incredible work that he's done and the lives he's touched. I unfortunately did not have an opportunity to develop much of a relationship with Senator Sinclair, but I had, anyone who knows me well knows I have to fly to Winnipeg in order to get home. So I had the opportunity to sit with him on a few planes, and always appreciated the opportunity to seek his guidance, and he was never reluctant to hold anything back. He always open to a discussion with anybody about any subject to advance reconciliation and ensure that we're moving forward together. And I appreciated his wisdom and my ability, my opportunity rather, to lean on that in the few opportunities that I had, and I only wish I was able to do so more often. But I just want to thank him for his contributions to our country. As the previous speaker mentioned, thank his family for sharing him with us, and offer my condolences to his friends, family, loved ones, and really just ensure that on behalf of, I think on every one of our committee, understanding his inspiration will live on, and his work will continue, hopefully through us, to the best of our abilities. Thank you.
Thank you very much, Mr. Melillo, and I do want to thank all members for sharing their thoughts at a very difficult time right now. But with that, we are going to move into clause-by-clause consideration. Pursuant to the order of reference of Wednesday, June 5th, 2024, the committee resumed consideration of Bill C-61, an act respecting water, source water, drinking water, wastewater, and related infrastructure on First Nation lands. And to help us with the clause-by-clause consideration of Bill C-61, I would now like to welcome our witnesses. We have Nelson Barbosa, the Director General, Community Infrastructure Branch of the Department of Indigenous Services. We have Rebecca Blake, the Acting Director, Legislation, Engagement, and Regulations. And we have Douglas Fairburn, Senior Counsel, Crown Indigenous Relations and Northern Affairs. I want to remind members that the amendments are confidential and sub-amendments are to be shared electronically or in paper in both official languages and sent to the clerk for distribution. I'd also like to provide members of the committee with a few comments on how the committee will proceed with the clause-by-clause consideration of Bill C-61. As the name indicates, this is an examination of all the clauses in the order in which they appear in the bill. I will call each clause successively, and each clause is subject to debate and a vote. If there are amendments to the clause in question, I will recognize the member proposing it, who then may explain it. In addition to having to be properly drafted in a legal sense, amendments must also be procedurally admissible. The chair may be called upon to rule amendments inadmissible if they go against the principle of the bill or beyond the scope of the bill, both of which were adopted by the House when it agreed to the bill at second reading, or if they offend the financial prerogative of the Crown. Amendments have been given a number in the top right corner to indicate which party submitted them. There is no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. Approval from the mover of the amendment is not required. Sub-amendments must be provided in writing. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Finally, if members have any questions regarding the procedural admissibility of amendments, the legislative clerks are here to my right to assist the committee. However, they are not legal drafters. Should members require assistance with drafting a sub-amendment, they must contact the Legislative Council. So I thank members for their attention and wish everyone a productive clause-by-clause consideration of Bill C-61. Okay. So with that, let's get into it. And I would like to propose something before we start with the first clause. And this is with Clause 2. Because since there are a few amendments to Clause 2, the definitions clause, I suggest that we postpone the study of Clause 2 until the end. This will allow us to first consider and then make a decision on amendments that could have an impact on the definitions. As a reminder, the definitions clause of a bill is not the place to propose a substantive amendment to a bill unless other amendments have been adopted that would warrant amendments to the definition clause. So with that, I do want to ask the committee if there is unanimous consent that we defer this until the end of clause-by-clause consideration. Okay. Okay. It sounds like there is consent. So therefore, Clause 2 will be postponed and we will be considered after Clause 44. Okay. So with that, we are going to start on Clause 3, and this is NDP 6. So I will provide the opportunity if someone would like to move NDP 6. And Ms. Idlout.
Thank you. My apology. I did not understand the process. My question is, I do want to eliminate some of the amendments that I brought forward, or can I say the numbers, or should I be writing them down?
Ms. Idlout, you may say the different amendments that you don't want to move, or you may also just not move them. So there's no requirement that you actually move those ones, but if that would be preferable for you, if you provide those up front, then it would just maybe speed up the process as well.
Yeah.
I just want to let you know that I will be removing these ones. I will not include the numbers. NDP 50, NDP 18, NDP 26, and also NDP 78.
Thank you very much, Ms. Idlout. And just for clarification, it was NDP 15, 18, 26, and 78. Thank you very much. Okay. But with that, Ms. Idlout, you still have the floor for NDP 6.
Yes, thank you. I will move the NDP 6 with identifier 133-77319. I want to move this. I want to support the people who gave us the Blackfoot Confederation, who gave us this consideration. And the title of the First Nations peoples, the name of the title of, if that makes sense.
Thank you very much, Ms. Idlout. Do we have any members that would like to speak to this amendment? Mr. Schmale and then Ms. Atwell.
Thank you, Chair. I think my question just revolves around S13. I believe that piece of legislation is nearing potential completion in the House, I guess, whenever the House leaders do it. So it's my understanding this gets repealed if S13 passes. That's the non-derogation clause. What's that?
I don't understand, Jamie. Are you saying that the non-derogation clause may lead to a different definition of First Nations? I wasn't following.
If it was redundant or not, I guess that was my overall question.
No, I don't think they're connected.
Okay.
Shmail, that may be a question to ask the officials. So if we might be able to turn the floor over to perhaps Mr. Fairburn.
Yes, I would say they're not connected. There is a provision later on that deals with non-derogation, but this would be strictly with respect to the definition of whether it's Indigenous peoples or First Nation peoples.
Okay.
Yeah.
Thank you very much, Mr. Shmail. Ms. Atwin.
Just again on, so I think it differentiates between Indigenous rights and First Nation rights, and the bill specifically focusing on affirming rights on First Nation land. And so I think it just reiterates again that it's the federal government who's deciding who is considered First Nation under the Act, and we want to make sure that communities themselves have that ability to determine who and who isn't. It's up to them. So I think it's about maintaining the flexibility around that definition, creating space for First Nation communities to have that definition for themselves. And so it's, we'd like to co-develop with those communities, which is, I think, enshrined within the bill itself. And so it's certainly, we understand why it's there. But it's about, for me, creating new definitions of First Nations on First Nations, and it's additional layers. And so I think it's actually limiting to Indigenous communities for determining their own identity.
Ms. Idlo.
And I want to answer the question. I've made it not clear. Maybe our consultants can better answer this, or the advisors. Sorry. And in here, when you read the Bill C-61, when you read Indigenous peoples, as through Indigenous peoples, there's three distinctions. There's Inuit, First Nations, and the Métis. So we're all under the Indigenous umbrella. I'm just trying to make it clear that this is pertaining to First Nations. It doesn't include Inuit, and it doesn't include Métis people.
Thank you very much, Ms. Idlo. I have Mr. Melillo.
Thank you, Chair. I just, to that point, Ms. Idlo's point, obviously this act is pertaining directly to First Nations specifically. I'm wondering, maybe it's a question of our witnesses, if there was a specific purpose with using the terminology Indigenous people over First Nations. It seems to me like in the context of this bill, it would make more sense to use the term First Nations, because that's what we're specifically discussing is First Nations clean water. Was there any specific reason why Indigenous peoples was used in this clause versus First Nations?
The Constitution refers to the Aboriginal peoples of Canada, and it includes Indian, the term used in the Constitution, Indians, Métis, and Inuit. So it was meant to be essentially an inclusive term to reflect the Constitution with the change of Indigenous versus Aboriginal, but otherwise it was to reflect the Constitution.
Okay. If I may again, Mr. Chair. Thank you. So would this change have truly any tangible impact in terms of changing the substance of the bill, or would it be, maybe I'll just leave the question at that.
I think in the context of this bill, it should not affect other pieces of legislation. For example, it's referring to an element of what's in the Constitution, but it's not trying to limit the rest of the term.
Okay, thank you.
Okay, is there any other members that might want to make an intervention? Okay, well, if not, I'm going to call a vote on this one. Shall NDP 6 carry?
A recorded vote?
Yeah.
Okay.
But I don't, I'll ask the committee, if we feel we need to have a recorded vote on each of these. I think it might be, I think it might take some time. Obviously, we're trying to get this through. I would suggest it might make more sense to, I mean, obviously, if there's a contentious issue, that would be different.
Let's call a vote on this one.
Okay.
We can determine if we need to do that later, but we're calling a vote for this one.
Okay, thank you, Mr. Chair. Mr. Baptiste?
No.
Mr. Carr?
No.
Ms. Adwin?
No.
Mr. Hanley?
No.
Mr. McLeod?
No.
Mr. Melillo?
Yes.
Mr. Schmel?
Yes.
Mr. Epp?
Yes.
Mr. Zimmer?
Yes.
Monsieur Lemire?
En faveur.
Ms. Idlout?
I say yes.
So, yeas pour 6, and nays contre 5, 5.
Okay, well, with that, NDP 6 passes. So with that, we are moving on. So PV1 is deemed moved pursuant to the routine motion adopted by the committee on December 15th, 2021. Since PV1 has been moved, BQ2 and NDP 7 cannot be moved as they are identical. Also, PV1, NDP 8, and G1 seek to introduce similar concepts.
Point of order, Mr. Chair. Just a quick question. As this is a Indigenous Services Canada file as opposed to a Crown Indigenous Relations file, I'm wondering if there's a reason why I went first as opposed to Ms. Atwin in terms of the vote, just because as she's guiding the ship on this, I'm looking to her for moving forward. If the order is alphabetical, it should start with her name. But if there's a reason we're starting with me first, I'd like to know why. Because just it would simplify things if Jenica went first as opposed to me.
So just thanks for the intervention there, Mr. Batiste. So my understanding is it is done in alphabetical way, but because there was substitutions, it was done on the original members or the standing member of the committee.
So what does that mean moving forward? Because A usually comes before B.
Going forward, we will start with Ms. Atwin. Okay, so with that, I was just about to hand the floor to Mr. Morris to speak to PV1.
Thank you, Chair. I want to start by sharing that all of the amendments I brought forward to committee on C61 come directly from the testimony we heard from 6 nations of the Grand River, this one included. I'm really glad to see that both the Bloc and NDP have put forward the same amendment. I'll read out the amendment for the committee. It adds to Clause 3, which is the rights section of the bill. It is hereby recognized and affirmed that, in accordance with the principle established by Resolution 64-292, adopted by the UN General Assembly on July 28, 2010, which recognized access to clean and safe drinking water as a human right essential to the full enjoyment of life and all other human rights. All members of all First Nations residing on First Nation lands are entitled to have accessible drinking water that poses no risks to their health or well-being. What we heard from Chief Hill and in correspondence with 6 Nations directly, their view very clearly. If this bill does not declare the provision of water as a human right, the health and well-being of their on-reserve community members will continue to be negatively impacted. To them, it's self-evident, and by putting this forward, I strongly agree. that no person, plant, or animal can survive without water. It seems like a really critical addition to ensure we that this committee enshrine in this bill the very clear human right to water that is not already included in the bill. Thank you.
Thank you very much, Mr. Morris. Putting together a speaking list, I first have Ms. Atwin.
Thank you, Mr. Chair. And thank you, Mr. Morris, for being with us today, too, and putting forward this incredibly important amendment. I think you'll notice from the package that there's definite alignment. We absolutely support the human right to water. We've heard witnesses as well. We've heard how this has impacted communities for decades. The only issue for me is just in kind of the expansion of the language, that we want to make sure that it's actually leading to stronger protections for First Nations. And so we really want a simplified focus, which you'll see in G1. And so I won't be supporting it in its current form because I prefer the language. I think it's stronger as far as the legal terminology, and it's also simpler for those who might be reading the bill and application of the bill. And so I won't be supporting this piece, but you'll see G1, absolutely the human right to water we want to support.
Thank you very much, Ms. Atwin. Next on the speaking list, I have Mr. Malillo.
Thank you, Mr. Chair. I too want to acknowledge Mr. Morris for being here, and thank you for that. Obviously, a very important amendment. I do actually agree with Ms. Atwin. I don't know why I sounded surprised about that, but I do agree. I think G1 is just simpler, more straightforward from my perspective. So I would be more inclined to not adopt the next few here and go towards G1.
Hello. Next, I have Ms. Idlout.
I have a question for the expert. What is PV1? What's the difference between PV1 and G1? Can you explain this, please?
Essentially, both would recognize a human right to safe drinking water on First Nation lands. So they are very similar in their scope and in their the outcome. So I'd say very little difference.
Very much, Ms. Idlout. Is there any other interventions to a vote?
Mr. Chair, if I can just ask quickly of our witnesses as well. I think obviously there's a desire for the sentiment of this. I'm curious if you have thoughts about how this would be upheld as a human right. I think there are certain challenges, frankly, that could come with it. Obviously, there's labor issues, training issues in terms of water plants. I think there are a lot of things that in reality could make it much more difficult than simply affirming it as a human right is one thing. I'm just curious if you have thoughts about how that would happen in terms of ensuring that is actually upheld.
Yes. There is some uncertainty now about the scope of the human right, safe drinking water on First Nation lands. We think it would likely, if it were challenged in terms of the right, be left to the courts to decide. There's the potential for a judicial review, for example, of the of decision that seems contrary to the human right to safe drinking water. I would note one difference, and that is later amendments refer to this right recognized within the scope of the Act. And the idea is that courts or decision makers would look to the Act to determine how that right is to be fulfilled. And some of the elements of that are, for example, the minister's requirement to make best efforts to ensure safe drinking water on First Nation lands. So those types of provisions, the provisions dealing with funding, would all inform the human right to safe drinking water, at least in terms of the government amendment, and that's not as clear in this amendment here before us.
Thank you, Mr. Milo. Ms. Idlout.
What I also noticed the difference between C61 and G1, though, is that when I read C61, I appreciate it more because it refers to international law and Canada's obligations accorded through international law. And I wonder what weight that gives to Canada recognizing human right to water because of the international obligations it owes.
So the international law would inform Canada's recognition of human right to water if that were to occur. I would say neither of these would directly import into domestic law the international human right to water. It's at international law, Canada has an obligation to progressively realize the right to safe drinking water for all Canadians. And so these provisions, particularly the government amendment, would be targeted at trying to realize that right and strengthen that right.
Have the floor.
Okay, just a follow-up. So Canada will actually look better if we pass PV1 because of international law. Like we're trying to show that we want to help implement the obligations given through international law.
I don't know if you...
Yeah, I think like maybe, I'm not sure about the term look better. I think maybe the nuance is the entrenching of a domestic right compels Canada towards a duty, in this case, to provide access to clean and safe drinking water. So the domestic law proposed in say, motion G1 clarifies that duty in a crisp way. The inference around the international law is less binding in terms of its compelling nature on the duty to provide clean and access to safe drinking water in First Nations land. So one, I would say, is more of an international recognition of Canada's commitment in the international space. The other is entrenching a domestic law which compels Canada to essentially provide duty.
So does that mean that realistically that PV1 and G1 are two very different pieces of clauses that can both be passed?
I think in my mind, and I would turn to Doug as well, I think they would be competing. They do speak to both entrenching a duty. I would just say that particularly in an act that has been reviewed carefully by many First Nations people, including witnesses that have come to this committee, clarity of language is abundantly important. And if the intent of these clauses, which seem to overlap a little bit, is to entrench a domestic law, I think the objective would be to have the utmost clarity of what that law compels Canada to do. I don't know, Doug, if you want to add.
Yes, I'd agree with that. The government amendment is also a recognition of that right, and of the importance that the Government of Canada and Parliament feel. So I would say the government amendment does tend to might be a little stronger than this one in some respects. Yeah. And I think that the main reason for that is because it's to be there is a reference to the other obligations in the Act. It's in accordance with the Act, whereas the PV1 doesn't mention the Act itself.
Okay, I'm so sorry.
One more there.
So in G1, when it says at the last part of the clause, when it says in accordance with this act, does that not limit that human right just with this act?
The right is on First Nation land, so that is one of the limitations. But in accordance with the act would be what directs people to look at the act to give life to that human right that's recognized in the act.
So if we were to amend G1 to say in accordance with this act, that human right would still be generated?
Yes, the current G1 does recognize the right, human right to safe drinking water. So it is a right that people would be able to look to the courts. Again, we're not certain exactly the scope and what a court might say in that context. It's because Canada has not recognized in a right, human right anywhere. Quebec actually is one exception where they have a limited recognition. So it is a bit of a new concept, and the scope is unknown.
Next on the speaking list, I have Mr. Morris.
Yeah, thank you, Chair. I just want to call out a few points for the committee. The first is that PV1 stands on its own with the reference to the UN General Assembly resolution within commas. The sentence, "It is hereby recognized and affirmed that all members of all First Nations residing on First Nations land are entitled to have accessible drinking water that poses no risk to their health or well-being," works, and then also has this reference to international law. So I think that's something important for the committee to note. Should the committee wish to pursue G1, I would encourage committee members to consider an amendment to G1, which currently says it is recognized that it is a human right, without the word affirm. I guess if I can turn a question to witnesses, would it not be stronger language to not only recognize a thing to be true, but to recognize and affirm that that is true?
Yes, I think you could use both recognize and affirm, yes.
I think that was the question I was hearing from Lori, was about which would be stronger language. And so I appreciate the clarity from witnesses that if the committee pursues G1, the committee could consider adding affirm to that language. And while I have the floor, I would add that in accordance with this act would seem to limit that right should the act be seen as insufficient. And so I think the committee could also consider, when it gets to G1, whether that strengthens it without that additional language. Thank you, Chair, for the intervention.
Mr. Morris. Next on the list, I have Mr. Batiste.
Yes, it's my understanding that G1 is kind of a historic statement, as the government has never acknowledged the human right to water, and that this amendment would formally recognize that First Nations have a human right to clean and safe drinking water, in itself recognizing it as a federal government coming from Canada, as opposed to its reliance on international law. And I believe that makes it a stronger statement. Can you go into a little bit of the thinking of why G1 was important to stand on it alone without the reference to international law?
Thank you. Perfect. Thank you very much for the question. Absolutely. It would be historic to recognize it in domestic law. As in addition to what my colleague has mentioned, international law can be challenging to create a binding circumstance with, where in domestic law it's up to the federal parliament to ensure it's binding. So there is that addition. I would also just mention a couple things. One is in relation to the implementation. So going back to another question that was asked, so in accordance to the Act does provide guidance on implementation of that right. So that's one core component. In addition, the all members of First Nations versus every individual. So G1 is drafted to be inclusive to every individual on First Nation lands. So it could be individuals that are not members of a First Nation as well. Thank you.
Next, I have Ms. Atwin.
I was just going to ask specifically about the piece around in accordance with this act for clarification, but you very much did that for me as far as providing guidance on the implementation, so thank you.
Okay, are there others that'd like to make an intervention? Mr. Malillo.
Thank you, Mr. Chair, and I appreciate the discussion we've had so far. I don't want to look too far ahead, but I did look too far ahead to the ending of the act and thinking of Clause 43. Of course, if S13 does receive royal assent, then it is my understanding that that this clause we were discussing amendments to would be removed completely, if I read that correctly. So I'm wondering, obviously we're looking to include this human right in Clause 3, but if S13 does receive royal assent, what impact does that have then on the human right in Canada?
Were you referring to the non-derogation clause that would be
referring to Clause 43 at the end of our act here mentions if Bill S13 does receive royal assent, that Section 3 of this act would no longer be in force. If I read it correctly, okay, please correct me if I'm wrong. So I'm curious from that standpoint.
Appreciate the question.
Sorry?
It is separate.
Okay.
So Clause 43 is specific to non-derogation of
Okay.
Indigenous rights. So this would be beyond Indigenous rights and a recognition of a human right to safe drinking water.
Okay, so it wouldn't have any impact on,
Exactly.
on that. Okay, thank you.
You're welcome.
Thank you very much, Mr. Malillo. I see Ms. Idlo has her hands up. Ms. Idlo.
Thank you. So if S13 passes, the purpose of Section 3 is to outline that there are rights to be upheld because of the Constitution. So then the two amendments that we've suggested is adding what's the word? I can't think of it in Inuktitut or English. Because the difference between PV1 and G1, PV1, when I suggested my own amendment, that's very similar. It was because it was the Blackfoot Confederacy that also wanted this clause. So for them to understand that Section 3, if S13 passes, does not impact their right to water because of the passing of S13. So the purpose of recognizing that right, whether it's a great, wonderful thing or not, or that we've made an attempt to enshrine international law into this bill, won't matter anyway if S13 passes.
If it passes, it would basically change Clause 3. Yeah, it would take 3, replace, in effect, 3. But it shouldn't affect the reference to the human right to water. That would still exist, that clause, if it were adopted by the committee.
Thank you very much, Ms. Idlout. Next on the list, I have Ms. Atwin, and then après ça, Monsieur Lemire.
Just kind of combining all of our thoughts here, perhaps we add to, so I'm looking at G1, to add the is recognized and affirmed piece, but then also after that reference the international human rights, and then it's kind of all, it's all there. If that's the simpler one. Okay, how about the affirmed? You good with adding that piece?
Yeah.
G1 is fine.
Almost there? Okay.
With you and I, it'll pass, so.
Yep, that's fine then. Okay.
Merci beaucoup, Madame.
Thank you, Ms. Atwin. Mr. Lemire? Thank you, Mr. Chair. I'd just like to mention that we'd like to support the consensus on G1.
Okay. Ms. Idlout.
Recommend making an amendment to G1 to remove the last few words that say in accordance with this act so that it ends at water.
And that we'll have to get to that amendment to do that, but we'll circle back to that in a minute. Good.
Whether we can
Okay,
sub-amend
so
something we're not on.
so it seems like we have consensus here at this point that, well, I guess I could say here, will NDP, or sorry, will PV1 carry?
No.
No? Okay. Let's say, okay. It's not going to carry. I don't think we need to do a recorded vote on that. And given that BQ2 and NDP7 are identical, they will also not be carried. But shall clause 3 carry?
G1.
But that's on.
It's clause 3 still.
That'll be 3.1 afterwards.
PV1 is defeated.
Yes. So we need to first vote on clause 3 before we get to NDP 8 and G1. Okay. Looks like on division. Carried.
What's carried?
Clause 3.
Oh, okay.
Yes. As amended by NDP 6. Great. Well, with that, we are moving to NDP 8. Would someone like to move NDP 8? Ms. Idlout.
Yes. Yeah, referring to NDP 8, reference number 133-70724. It was given to us by the Black Food Confederacy. The written for the text is probably the same, but the international, I want international law to be included in there. That's my comments. Thank you.
Thank you very much, Ms. Idlout. Would anybody else like to make an intervention related to NDP 8? Okay. Mr. Melillo.
Just quickly, Mr. Chair, I would again, I think this is a discussion we just had, and we still favor G1, so we'll be voting against this.
Okay, so then shall NDP 8 carry? Doesn't. So I'll say on division, it doesn't pass. No, I said it does. It doesn't pass on division.
No.
No? Okay, sorry, there's
Yeah,
a bit of confusion here, but it's
defeated.
Defeated.
Laura, are you asking for a recorded vote?
Okay, well, we can do a recorded vote
Yeah,
then.
because I want to show my vote.
Okay, then let's do a recorded vote.
Ms. Atwin?
No.
Mr. Baptiste? No. Mr. Carr?
No.
Mr. Anley?
No.
Mr. McLeod?
No.
Mr. Epp?
No. No.
Mr. Melillo?
No.
Mr. Schmel?
No.
Mr. Zimmer?
No.
Monsieur Lemire?
Contre.
Ms. Idlout?
I say yes.
Okay. Nays, yeas pour 1, and nays contre 10, 10.
Okay, so NDP 8 is defeated.
Can I do a quick point of order, Chair?
Sure.
Okay,
Mr.
just to
Smith.
follow up on Mr. Batiste on the voting order. Eric is the lead for this on our side, so if he could kick off the voting, I know it might mess people up. But
Mr. Epp is new, you know.
yeah, he's
Very grateful to welcome Mr. Epp to the committee today, but I think there's no reason why we shouldn't be able to start on the Conservative side with Mr. Melillo.
I don't know if you want to check with the bloc or NDP on their voting structure, but wants to start with them.
Okay, so colleagues, we're gonna move to G1. Someone like to move G1? Ms. Owen.
Thank you very much. So moving that Bill C-61 be amended by adding after line 8 on page 6 the following: the right to clean and safe drinking water. It is recognized and affirmed, I believe we should add that piece, that it is a human right of every individual on First Nations land to have access to clean and safe drinking water in accordance with this act. I do want to include that final piece because I do think it strengthens it by providing that guidance as far as the implementation piece, and that's specifically how it is drafted, and it helps explain things for me as well. I think the key here is also clarity for our partners and for those who will be most affected by this. Very important piece of the legislation. I just, in general, also feel incredibly privileged and honored to be part of this historic conversation, and to put an end, hopefully, to the historic discrimination that has led us to this point. And so I'm very excited specifically about this piece. And again, I think we've all kind of arrived here in a good way. It's been an honor to work with you all to get to this point. So I move G1. Thank you.
Thank you very much, Ms. Atwin. Just for clarification, you can't sub-amend your own amendment, but it's up to colleagues if someone would like to make that sub-amendment. But I just want to also remind members that those sub-amendments need to be submitted in writing so that they can be translated as well. So if someone is interested in doing that sub-amendment, then we'll have to go through that process. So first we have Mr. Melillo to speak to G1.
Thank you, Mr. Chair. As we've been talking about for some time now, still in favor of the wording here in G1. I also support including it is recognized and affirmed. So I am happy to make that sub-amendment, Mr. Chair. If you'll indulge me, I'll need a second just to make sure I have my translation correct and have that circulated. But I'm happy to move that sub-amendment.
Great.
Maybe just a point of order, or would it be possible to get like a brief suspension just to give time for us to get that circulated?
Absolutely. We can briefly suspend here while that sub-amendment will be circulated, and then we will continue right after with the list that we have here. So we're going to briefly suspend. At this point, you will have received an email with the text of the sub-amendment, both in English and in French. Mr. Melillo has the floor here in moving the amendment, and I'll turn it back to him, or the sub-amendment, I'll turn it back to him.
Thank you, Mr. Chair. I'm happy to move this sub-amendment. I won't take up much time, but maybe just I'll just read it quickly so everyone is on the same page. So it would read as follows: It is recognized and affirmed that it is a human right of every individual on First Nations land to have access to clean and safe drinking water in accordance with this act. It's been discussed, so I think I'll leave it there and move it at this point. Thank you.
All right, is there anybody that would like to weigh in on intervention? I see Ms. Idlow with her hand up.
Quick question to the expert witnesses, if they can identify how different are they if they were to be if this were to be removed in accordance with this act. If this were to be removed, how would the definition change? How can you explain if they were to be still included?
Thank you for the question. The in accordance with the Act really provides that guideline for implementation. So that is the core piece. With that added, there is quite a bit of guidance throughout the bill to actually implement a human right to safe drinking water. With it removed, it would be more up to the courts and less done in consultation and cooperation with First Nations.
Thank you.
Thank you very much, Ms. Idlow. Is there anybody else that would like to make an intervention? Monsieur Lemire?
I don't know if I'm saying this at the right time, Mr. Chair, but I'm just wondering about Clause 34 and the rest and what it's referencing. We're on G1 right now. Will Clause 3 be used, or does the committee want to offer this a more historical scope and a more confirmed approach?
Monsieur Lemire, est-ce que vous voulez...
Mr. Lemire, do you want to ask a question to the witnesses? Yes, essentially the question is, will 43 remain since we're changing Clause 3 and we're adding 3.1? The fact that the committee is clearly stating that it wants to enshrine this historical precedent in the bill. Will this allow us to keep Clause 3 and therefore Clause 43 may be modified in consequence?
So, Clause 43 is the coordinating amendment that refers to Bill S-13, which would be an amendment to the Interpretation Act, and that would essentially bring into a new non-derogation clause that would apply to all federal statutes. So that would replace the existing non-derogation clause in Clause 3 of this Act if the Interpretation Act amendment were to pass.
Okay. Donc, est-ce que, en fait, la question...
So the question is it the will of the committee to enshrine this precedent in G1 to recognize the historical element here? If this is the will of the committee, then if 43 is adopted, then this creates a precedent. Is this an issue for the committee? That's what I'm trying to express.
Perspective. So the Clause 43 would only impact the existing 3.1. It wouldn't impact any other 3 clauses that would be added. So should the committee decide to go forward with that historic opportunity, that would be different than the existing 3.1, and there'd be no impacts if the S bill did pass.
Okay.
Merci beaucoup.
Thank you very much, Mr. Lemire.
Is there anybody else that would like to weigh in before we move to a vote? Okay. In that case, shall G1 carry? Wait. Oh, sorry. Apologies. Shall the sub-amendment carry? Okay. Seeing we have unanimous consent here. It's great. So G1 is sub-amended according to the text that was circulated. Does anybody want to make an intervention related to G1 as amended, as sub-amended? Okay. Mr. Batiste.
I think, Mr. Chair, it'd be helpful to the committee in their discussion around 43. If this is 3.1, does that change? Like, do we need this to be 3.2 as opposed to 3.1 to be consistent with what's being said in number 43? Because there continues to be this discussion around the non-derogation clause that is currently 3.1 that we're saying is now 3.1 according to that state. So is this 3.2 that we just put forward? So 3 is the non-derogation. 3.1 is what we just amended, correct? And so in 43, which, if I'm reading correctly, talks to section 3. Okay, so we're okay with just this, the non-derogation clause being section 3, but this being 3.1, correct? And that being different. Yes? Yes? Okay. Okay. Okay.
So maybe I'll turn to the officials here, and just one other thing I'll mention is at the end of this process, the Legislative Council will go through all of the numbering as well.
So yes, section or clause 3.1 is different than the 3 sub 1 or 3 sub 2. So even if 3 sub 1 and 2 were repealed, clause 43 would not affect clause 3.1. Okay.
Thank you very much for that clarification, Mr. Batiste. Are there any other members that would like to weigh in before we move to a vote on G1 as amended, sub-amended? Mr. Malillo?
I don't want to belabor this because I think we got to an understanding here, but would it be appropriate to ask a question related to 43 since it was brought up, or should I hold on to that for now? Just wondering because it's fresh in my mind.
Mr. Malillo, if you'd like to ask a question related to that now, that's fine. We will get to that, but not for some time.
And I hope this doesn't spiral, but I'm just because it was brought up. Is the intent of 43 to remove 3? I suppose is it based on it becoming redundant? Is that sort of the idea of why it would be removed? Okay,
that's right. The Interpretation Act would have a standard non-derogation clause because there are differences in each of the federal statutes. Some of them are worded differently, so it'll be a standard provision which would would apply to all federal acts, and the existing non-derogation clauses would be repealed in this act and in all other federal acts.
Okay, thank you. Thank you, Chair.
Thank you very much, Mr. Malillo. Okay, with that, shall G1 as sub-amended carry? Okay, looks like we have unanimous consent. Carried. With that, we're going to move on. Next, we're going to be moving to Clause 4. The first...
But we have to vote on Clause 3 first? No?
So we already, Mr. Malillo, we already did vote on that one before, but because we added the amendments afterwards, we don't vote on it again.
that's right. Okay. I'm just keeping you on your toes.
On division.
But thanks for that clarification, Mr. Melillo. So at this point, we're moving on to Clause 4. And the first amendment we have that was submitted is NDP 9. So, Ms. Idlaut, you have the floor.
Thank you, Chairperson. This NDP 9, reference number 13369-427. I will start by Clause 4 to be amended. This was the way it's written. They want this amended to. So thank you.
Thank you very much, Ms. Idlaut. I see Ms. Atwin has her hand up. I'll turn the floor over to you, Ms. Atwin.
Yeah, I think it just adds further clarity. I think that's what we've all been looking for in partners as well, so we certainly support that amendment.
Great. Thank you very much, Ms. Atwin. Next, I'll move over to Mr. Melillo.
Sorry, Chair. Mr. Schmale was speaking to himself, so it was distracting me. But I did have my hand raised.
Thinking out loud.
He was thinking out loud. So I'm happy I got that on the record.
You know I was paying attention.
Okay. So I definitely understand what NDP 9 is hoping to achieve. I have a question, I guess, about how it fits with some of the rest of the bill, considering Clause 6 and 6B, which highlight that that these First Nation laws would be applied based on consultation and cooperation with provinces and territories as well. Would NDP, and I suppose this is the question to the witnesses, would NDP 9 contradict that in any way as it's written?
Yeah, thank you. Thank you for the question. In short, no. Wouldn't contradict. No, it does not.
So I could.
No, it does not contradict. I think as the bill is written, the protection zone must be agreed to, as you know, by provinces and territories and willing First Nations. So should a protection zone exist, it would be agreed to bilaterally or trilaterally with those partners. So this, and as to your question, does NDP 9 contradict or undermine Provision 6? I would say it does not.
Thank you. Do you have any questions on this?
Mr. Melillo, et à ce moment, je vais.
I will now go to Mr. Lemire. Thank you, Mr. Chair. I just wanted to mention that we all had the same concerns at the beginning, but for the Bloc Québécois, we're unable to determine the inherent rights to a land that could overlap on lands that are not First Nation lands, so we're going to vote against the amendment for that reason.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Lemire.
Mr. Schmale.
Okay, perhaps to our officials. Just to clarify here, we're talking about the source water in protection zones. Unless I missed it, do we still have a definition of what a protection zone is yet? No?
No.
Okay, so we're I think I'm landing with Sebastian on this one. So we are making, I guess, some changes to a section of the bill that we have yet to define in this legislation. I guess it's up to potentially depends on how this plays out, the minister and his or her best efforts, I guess, but I guess that's still to be determined as we get through this. Yeah, I think at this point, I think we're leaning towards Sebastian's here. And what about source water? Have we defined source water? Not yet.
No.
So we haven't defined source water. We haven't defined protection zones. Okay, I think that's a little a touch concerning. I know that might get defined as we go along here, but especially if we are starting to add it to sections that haven't been defined, I think that's a bit problematic. So at this point, unless we are able to get through this and define it, I think we're going to vote no as well.
Thank you, Mr. Schmale. Mr. Batiste.
Yes, I'm wondering about where this would go, line 20, and if you could just explain a little bit how this strengthens this paragraph, because I'm not really sure if it does, and I'm just trying to figure out how it strengthens it in this, especially in light of the fact that there's no definition. And that's a question for, actually, I think I understand. Actually, I'm okay. I'm okay. Ben's back. No, I'm okay. I was thinking out loud.
Okay.
Sorry.
Thank you very much, Mr. Batiste. Ms. Udlo.
I was just going to ask the witnesses if they could elaborate on the differentiation between what the current 4B is and what adding my proposal would mean, if you could describe it.
Appreciate the question. In essence, in Section 6 that other folks have already raised, it does affirm the inherent right to water, source water, drinking water, wastewater, and related infrastructure on First Nation lands in A, as well as water and source water in protection zones if provinces and First Nations in Canada agree on an approach to coordinate laws. So in essence, in the purpose of the bill, the proposed amendment would reiterate some of those commitments that are later in the bill in Section 6, just under purpose.
Next, I have Mr. Zimmer.
Yeah, I guess I'm similarly questioning the protection provision, and I guess we've heard from so many witnesses that had similar concerns, provinces as well, around it, that I think it at least deserves a definition and very specific language around what that means, because its implications could be vast. And if we don't get that right, you know, and we all want, you know, to accomplish what this bill, I think, sets out to do, but you know, that is concerning, I'd say, for me, from Northern BC specifically. Thank you.
Thank you, Mr. Zimmer. Next, I have Mr. Melillo and then Ms. Idlo.
Thank you, Chair. Just a couple quick questions. I suppose at this point in the bill for the witnesses, would this change have a mechanical or tangible impact, or would it be more of a legal principle change, if that makes sense?
It'd be more of a legal principle than a tangible impact.
Okay, I appreciate that. And then I'll just say, and maybe Ms. Idlo could speak to this a bit. I know that there are many amendments, and we're going to have a lot further discussion around protection zones and First Nation consent in defining those protection zones. Would there be any concern? I'll just put this out, and if Ms. Idlo, if you want to comment on it, would there be any concern that including protection zones at this point, before we've done that work, to include First Nation voices, if we're sort of, I don't know if overstepping is the right word, but superseding some of those future amendments just for discussion?
Next, I'm going to turn the floor over to Ms. Idlo.
Thank you. Clarification. And maybe we need more clarification. Just because the way that I understand NDP 9, as it clearly makes it adds further clarity. I like the way that Jenica said it. With it being a proposal by the Assembly of First Nations, I do wonder what the whole process was I don't know if you guys were part of the process, because the way that this Bill C-61 was explained to us by the Minister of Indigenous Services was that this was co-developed. So if this was co-developed, I'm surprised to see that, and it was co-developed with the Assembly of First Nations. So I'm surprised to see the Assembly of First Nations submitting amendments. So I'm wondering if during the co-development process, if the Assembly had submitted these as provisions that they had wanted included in C-61, but they weren't, so they're hoping to still have them included through the committee stage. I don't know if you can answer that, but it would be super helpful to understand that one, first of all. Secondly, when we haven't discussed yet any kind of clarity for protection zones, if we do add clarity about what we mean by protection zones, how will that impact 4B and adding this?
For the question, I think on the first question about the years of work with the Assembly of First Nations and rights holders themselves, I think we heard a myriad of voices, and you heard many of those at the table. So certainly respect the fact that the FN submitted suggestions in order to improve the bill, and that's what's being deliberated today. I think, as my colleague had mentioned, the language being proposed in NDP 9 is analogous with language found in Clause 6. It's very similar. So it's affirming it in the purpose as opposed to in Section 6. On the second question on protection zones, I think we will speak at length, or the committee will speak at length about that. As currently written, the bill speaks about a consultation and cooperation process in order to define that, including with provinces and territories. So I think that is clear in the bill. Whether or not that's kind of how it translates in the future, it may be something else. But I think as written in your amendment in NDP 9, I would say it affirms some of the language that is found later on and brings it to the purpose section. And it does come from language that we've heard from many partners and through the consultation process. So I would acknowledge that as well, yes.
Thank you very much, Ms. Idlout. Next on the list, I have Mr. Schmale.
Okay, I would still want to continue this discussion about defining it, adding these terms and not actually defining it. I think we've seen in previous pieces of legislation where we did not define certain words. There was some issues later on down the road. If we choose not to define this at any point, this could be later on down the path of this legislation, what risks are we running here?
Yeah. What risks? I think, okay, so definition brings clarity, absolute clarity in law, which provides, I think, like a rubric or a boundary over what a protection zone could or how that'll be applied. I think the ancillary point to that, or the opposite point to that, it does become rigorous. And so should there be, as you've heard from many witnesses, the fabric and the realities of many First Nations vary considerably. And the definition for a protection zone should potentially respect kind of the geographic and historical differences across this country, including the relationship with provinces and territories. So I think the question is around entrenching in law a definition which does provide clarity the opposite side of the same coin is the rigidity of that language and the difficulty of changing that language once a bill becomes law.
Okay, I think, too, during the testimony, based on the differences we heard, I think, would it be fair to also say that unless we define it, it could mean different things to different people?
I think it is about aligning laws across multiple jurisdictions. And those laws can cover a variety of things, from clean drinking water to sanitation to quantity to flow to fire protections, many of the things that this bill speaks to. So it certainly could be applied differently across the country based on the joint agreement between a province, province territory, and a First Nation, yes.
Okay. Okay, I think we might have to either at some point before we finish this up have a, as you said earlier, some kind of direction in which we're going, or this could be very problematic. Whether now we define it before we finish this whole process, or there is some guards where the minister would have to consult or something like that. But I think, again, if we're leaving this, based on what you just said, which to me is pretty serious, I do have my concerns about not actually defining these key pieces that actually bring everything together in this whole bill we're calling C-61. I think that's a big risk, given the fact that we don't have a definition. It means something to somebody else. There's clarity with definitions. I think we might be doing a disservice if by the end of it, I'm not saying we'd do it right now, but if we don't work this out before the end, and we saw that with a few pieces of legislation here at this committee, where definitions were not provided in other pieces of legislation, which put everything into a very interesting and problematic role for certain groups. So I think we should definitely think about this before we get through this whole thing. But again, the fact that we don't have the definitions, I know Ms. Sidlight was saying it does allow clarity, but at the same time, we start adding in amendments like this without definitions, I think we open ourselves up and the Crown itself to potential issues down the road, which doesn't actually solve anything that we're trying to do. So I will leave it at that until I hear other questioners and maybe add some more.
Thank you, Mr. Schmale. On the speaking list, I have Ms. Idlout, then Ms. Atwin, then Mr. Milo.
Parking the vote or something, so until we get to protection zones. But while you're thinking about what the answer will be, I do just want to say again what I've said about Bill C-61 since we started studying it, is just to remind all parliamentarians that we got to this state of C-61 because of what was stolen from First Nations. What was stolen from First Nations is their authority and jurisdiction to manage and use their right of water through colonialism, through the Indian Act, through all these other pieces of legislation. And Bill C-61, as we understand it, is one form of reconciliation where that there's an attempt to give back that jurisdictions to First Nations. And to limit giving that jurisdiction back is just another form of injustice for First Nations. I just hope that you consider with this draft amendment that in strengthening this bill, you're strengthening reconciliation with First Nations, who for too long, we all know, all past governments have not done enough to invest in their infrastructure, but also to make sure that we're creating legislation that respects their authority, that respects their rights, so that we are doing the best we can to give back the jurisdiction that originally belonged to them as whole as possible, not in small parts here and there, including protection zones.
Thank you.
Next, I have Ms. Owen.
I just to agree with Ms. Idlow, it's really about stating clearly that First Nations have that lawmaking authority, and that as they've always should have had, and so it's that further assurance I think is really what our partners wanted to see. And I certainly hear the concerns of Mr. Smale for the definitions. I know we'll get to the definitions clause as a committee as well. So I think, with a vote, we could probably move on from this one. I'd rather not stand it. I'd rather keep going if possible.
Mr. Mlillo?
Thank you, Mr. Chair. I would agree. If it's up to Ms. Idlow, of course, if she wants to park it, I don't think it needs to be parked necessarily. I think we can move forward from this. I would just not to take away from what Mr. Schmale said, and I agree with much of his sentiment, but I would just, I guess urge caution in the discussion that obviously there's a lot of amendments dealing with protection zones. I think it's important that we have a wholesome discussion about that at the appropriate time. And I also think it's very important that we as a committee understand our role, in my opinion, should be to ensure that First Nation voices, provincial and territorial voices can be heard, that we are ensuring that there is free, prior, and informed consent of First Nations, for example. So I think that it's not necessarily it's time to get too rigid on that aspect of it. So I'll just end it there. I think we got a little bit deeper than just this amendment in our discussion, but I'm also happy to move this along to a vote if Ms. Idlow's agreeable.
Thank you, Mr. Mlillo, and maybe some of the discussion that we're having at this point will we'll make the discussion a little bit more streamlined as we get further along in the bill. But I'm not seeing any more interventions at this point. Maybe we can move it to a vote. So shall NDP 9 carry? I think we might need to go to a recorded vote for this.
Recorded vote?
Yes. The Liberals and NDP agree. Okay, well then we can do it on division then. Okay. Yep. So with that, NDP 9 is carried on division. Moving on here, so we're moving to NDP 10, but if it's moved, NDP 11 cannot be moved as it's identical to that. So we're at NDP 10, and I just give a moment here if someone would like to move NDP 10.
I have a quick procedural question while I have the floor. Just because I know that, when are we going to end our committee? Do I need to move to adjourn or something?
Well, thanks for that clarification or that question, Ms. Idlow. Today we have resources until 7:30. I do want us to take a health break fairly soon to take a break, but we do have resources up until that point.
So if I move to adjourn, is there a discussion?
If you move to adjourn, I think it's a dilatory motion, and we'll have to vote on it right away.
Because we would normally end, right?
Yeah, so Ms. Idlo, it was notified last Thursday that we had additional resources today that we could go for till 7:30. And so, but if you would like to move that motion, we can vote on it.
To move that motion.
Recorded vote. Okay, yeah. Ms. Atwin? No. Mr. Baptiste?
No.
Mr. Carr? No. Mr. Hanley?
No.
Mr. McLeod?
No.
Mr. Melillo?
Yes.
Mr. Schmerl?
Yes.
Mr. Zimmer?
Yes.
Mr. Epp?
Yes.
Monsieur Savard-Tremblay?
Oui.
Ms. Idlout?
Ang yakpong.
I say yes.
So yeas pour 6, and nays contre 5, 5.
Okay, so I guess with that, meeting adjourned.